Well, welcome everybody. My name's Andy Davis. I'm the Director of Research here at the Deason Center based at SMU Denman School of Law, located in Dallas. I'm delighted to see so many of you here, and I'll just say a few introductory remarks to give people a chance to arrive. My thanks to Kenitra Brown, who is right now organizing the administration of the waiting room, and also to Joellen Crisp, and also to Blaine Skiles, who are on the staff at the Deason Center, without whom we couldn't organize events like this. But we're especially excited to welcome Keah Henry from Indiana University Bloomington. She's an assistant professor in criminal justice there, who'll be presenting her work about prosecutorial discretion and its implication for disparities in the criminal legal system at large. We have these sessions occasionally to feature the work of new scholars in particular, and we are trying to create here a space for people to share their works in progress, their important work that is in the fields that we at the Deason Center are most interested in, one of which is prosecutorial discretion and reductions in inequality in the criminal legal system. So we're delighted that we located Professor Henry and that her work is so much on point. And Professor Henry's already shared a draft of a paper which I've had the privilege to review, and I'm really looking forward to hearing her presentation today. After Professor Henry's finished speaking, which we think will be in half an hour from now or something like that, there will be a chance for question and answers. We're a small enough group today that we probably will ask you just to unmute and speak your question. You should, of course, feel free also to put questions into chat. And then if that would be more appropriate, I can easily reiterate the question to Professor Henry myself. But we'll get there when we get there. Please do save your questions for the end, and we will have plenty of time for them. So think up some good ones. But in the meantime, I'm delighted to introduce Professor Keah Henry, and please take it away.
Thank you. As Andrew said, I'm Keah Henry. I'm an assistant professor in the Department of Criminal Justice at Indiana University Bloomington. My research broadly kind of centers on discretionary decision-making in the context of case processing and courts and sentencing. And so the paper that I'm going to be talking about today, the study that I'm going to be talking about today, is really going to center on that idea, specifically looking at something that I am calling the over-prosecution of communities of color, and the impacts that prosecutors can have in remedying some of that over-prosecution by the policies and programs that they put in place. So I'm going to go ahead and attempt to share my screen and hope this works out. Go. All right, everybody can see that okay, hopefully? Okay. So the title of my paper that is currently a work in progress is Diversion as a Remedy to Over-Prosecution and Limits to Achieving a More Equitable System. So the over-prosecution of communities has been at the forefront of social justice and criminal justice movements for some time now. There's been a lot less empirical research on this in the context of prosecution, specifically over-prosecution. And as gatekeepers to the justice system, prosecutors play a real integral role in limiting criminal justice contexts. They have considerable discretion on who to file charges against, the number and nature of those charges, whether charges are going to be dismissed, whether and what type of plea negotiations occur during this process, and whether those plea negotiations are even ultimately accepted. So given their central role in this system, stakeholders have increasingly required prosecutors to address certain issues around fairness, transparency, and equity in more direct ways. So in response to these calls, prosecutors have adopted a number of policies meant to divert individuals away from the system and to provide rehabilitative services to justice-involved individuals and remedy different inequities that were already established through prior policy mandates. Diversion programs are administered in a variety of different ways, but generally, they target defendants who have been charged with low-level nonviolent offenses with limited criminal histories. These programs are generally designed with a rehabilitative approach in mind. They are meant to emphasize public safety and to reduce negative consequences that may be inherent with criminal justice contacts. Additionally, diversion programs are often promoted as ways that prosecutors can reduce racial disparities in justice-related outcomes. So prior research suggests that their diversion programs have an ability to achieve these goals. However, that ability is relatively mixed, specifically when it relates to racial and ethnic minority participants enrolled in these programs. These programs are generally created or administered in a variety of different ways. However, there's a degree of variability that causes differences in these outcomes, and that can be due to issues of net widening or unequal program application across individuals who are enrolled. So the main purpose of this particular study is to examine the extent to which diversion programs actually reduce disparities across case processing outcomes. Specifically, I'm looking at the disparate treatment across different types of diversion programming and highlighting the differences between post and pre-program charges and their abilities to reduce disparities. So for the current study, I relied on data from a large urban prosecutor's office in the southern United States between 2017 and 2018. I selected this particular timeframe because it coincided with the election of the county's district attorney. This particular attorney represented the Democratic Party in the 2016 election, and they campaigned on a progressive prosecutor agenda, emphasizing fairness, transparency, public safety, and equal treatment for those individuals who are justice involved. After they officially began their term, the elected prosecutor introduced several different types of diversion programs. In general, these pretrial intervention programs were designed to give defendants opportunities to kind of forego additions to their criminal history and to reduce recidivism, as well as limit criminal justice contacts in the future. And they introduced two types of programs. So they introduced these post-charge initiatives as well as a pre-charge initiative. So post-charge initiatives that they introduced included things like a mental health diversion program, which helped address the needs of the mentally ill individuals who were arrested for some type of nonviolent offense. And it diverted those individuals from the traditional criminal justice system to a mental health division center that was created outside of the jail process. A Clean Communities program, which was essentially a community service program established for individuals who had committed a low-level offense to kind of work off their hours through a community service. A driving while intoxicated pretrial program, which allowed individuals who had been arrested on a DWI a second chance. They would undergo different types of assessments and participate in a developmental program that would individually create a treatment plan for those folks. A retail theft program, which required folks to have be have no criminal histories, this was their first offense, and be charged with a low-level retail theft. So things like stealing from stores and things like that. And then finally, a controlled substance abuse program that was meant to work with individuals who were suffering from addiction, and the addiction is what led them to commit certain types of offenses and crimes. Unique to this program was that once a person successfully completed, not only would their charge be dismissed, but they also had the opportunity to expunge prior drug offenses from their record, as well as any arrests related to a drug charge. So in order to kind of qualify or to participate in these programs, defendants would have to be, again, charged with a low-level nonviolent offense and have a minimal or no prior criminal record. Program participants would have to satisfy a number of different requirements before charges would be dismissed. And depending on the program, these requirements would range from completing community service to some type of substance abuse treatment or drug testing, and especially not being rearrested or reoffending while enrolled in the program. Now, the county's misdemeanor marijuana program is the exception to this particular type of diversion programs that I just previously described. Those were post-charge programs. Their marijuana program is actually a pre-charge program that would allow defendants who were detained on possession of a misdemeanor amount of marijuana to participate in a 2-hour drug and alcohol class that would be offered online at the via the district attorney's office. If they successfully completed, which they had 90 days to successfully complete this particular class, no charges would be filed. Really important to this particular program is that a person's criminal history did not bar them from participating. Really, the only way that a person would not be allowed to participate is if they were currently under criminal justice supervision. So if they were on probation or parole or already enrolled in the program, or if they were detained for possession in like a drug-free zone, so like a school or some other type of corrections facility. So the main research questions that I wanted to kind of address in this particular study was, one, do pretrial intervention programs reduce racial disparities among case dismissals? And two, does program type actually influence the extent to which racial disparities exist across these pretrial case dismissals? So as I mentioned before, these were the data that's used for this particular project is secondary data that we required from administrative prosecution records. These data were internally coded by the prosecutor's office. They provide a lot of rich information about offense characteristics as well as defendant characteristics, early case processing decisions, as well as case disposition outcomes. The final sample was limited to cases that were legally resolved by the prosecutor's office so that they had been disposed of legally. And it was also limited to information that was fully available for the selected variables in the analysis. So we excluded cases that had missing information on key variables. This led us to 2 different analytic samples. So our first sample is a pre-trial intervention sample with approximately 1,876 individuals, and then a drug offense sample with approximately 9,212 individuals. Because the primary purpose of this particular study is to examine prosecutors' decision-making during early case processing, specifically in the context of pretrial diversion programs, the dependent measure of interest is dismissal, or the decision to dismiss charges. So this was measured dichotomously, where a 0 would indicate that charges were actually affirmed and the case continued through system processing, and a 1 would indicate that a dismissal was achieved. Some of the primary dependent variables that I was kind of interested in was looking at the effects of race. These were coded using a series of dummy variables with white defendants being the reference. Importantly here, due to the sample size, Asian defendants and Latinx defendants are actually not included in the analysis because of missing information on the Latinx variable and the limited number of Asian defendants that were actually included in the sample. Sex is coded dichotomously, with females being coded as 0, males being coded as 1, and age at the time of offense is coded continuously or measured continuously. I also account for a series of legally relevant factors. Generally, courts research suggests that legally relevant factors are going to be driving these decisions. So things like offense level, offense severity, prior criminal record, and things like that. So offense level is coded 0 for misdemeanors, 1 for felonies. Offense severity is measured on an 8-point scale, with more severe offenses having higher criminal severity points. Multiple offenses is measured 0 and 1, with an individual being charged with 1 or more offenses coded as 1, and then a series of dummy variables to account for offense type, including violent offenses, drug, property, fraud, public order, motor vehicle, and then some other offenses. For this particular analysis, you'll notice that there are no violent offenses and there are no fraud offenses or some other offenses included in the analysis. Again, these types of programs are not designed for violent offenses, and fraud offenses are excluded just based on program design. Some other offenses were a small n, and so they were not included in the analysis. So the next series of analysis that I'm going to be talking about, one presents a descriptive model just to get an idea of who's enrolling in these programs and what are the characteristics of those individuals and the types of offenses that they are being charged with, as well as a series of multivariate models. The first model predicts case dismissal among defendants that were selected to participate in pretrial interventions. The second model predicts the likelihood of dismissal across pretrial interventions and across offense type. The third model looks at those decriminalization policies, so looking at the likelihood of dismissal for those who are charged with drug offenses, and then looking at the interaction between those who are charged with drug offenses, specifically simple possession of marijuana offenses. This first figure just kind of descriptively displays the process of how cases flow through the system at this particular time. So approximately 52,000 charges were referred to the prosecutor's office between 2017 and 2018. Of that amount, about 56% of those were actually charged, where about 44% of them were dismissed. Of those offenses that were charged, about 52% resulted in a conviction. A much smaller percentage received some type of divert adjudication or some other outcome. Other outcomes were the results of like the death of an individual or something like that. And only about 4% of these charges actually resulted in individuals enrolling in a pre-trial intervention program. So this table is just displaying the descriptive analysis for those individuals who actually enrolled or participated in a pretrial intervention program. An overwhelming amount of individuals who participated in these programs had their cases dismissed, and that's important to note. However, white defendants were overrepresented among participants, accounting for 59% of pretrial participants compared to the 43% of all cases referred. In contrast, Black defendants were underrepresented. They only accounted for about a little over a third of pretrial participants, but about 54% of all cases referred for prosecution. Asian defendants also slightly overrepresented in pretrial intervention program participants, representing about 5.7% of those participants, where they only accounted for about 1.5% of cases referred. Very few of these participants were charged with a felony, only about 16%, again, because these programs are not targeted for individuals mostly who committed felony offenses. Instead, they about 69% were actually charged with a Class B misdemeanor, followed by about 15% being charged with a Class A misdemeanor, or something called a state felony, which is somewhat in between a misdemeanor and a more severe felony. Pretrial intervention participants were generally going to be charged with some type of property offense. So thinking through that, like retail theft program, followed by drug offenses, public order offenses, and then motor vehicle offenses. So those DWI program participants. So this first analysis presents the factors that influence dismissal decisions for defendants enrolled in these programs. The results indicate that Black defendants were less likely to have their cases dismissed following a pretrial, their cases dismissed following pretrial intervention enrollment. The odds of dismissal were approximately 64% lower for Black defendants compared to white defendants. Also important to note here that other extra legal factors also influenced this outcome. Males were less likely to have their cases dismissed, whereas older defendants were more likely to have their cases dismissed. There are also some legally relevant factors that significantly influence this outcome in comparison to those who were enrolled in programs related to property offenses. Those enrolled in programs related to public order offenses or motor vehicle offenses were less likely to have their cases dismissed. There were no statistical differences between those enrolled in like drug treatment programs compared to those enrolled in property programs. This next series of analysis examined the extent to which these dismissals varied across offense types. So looking specifically at property, drug, public order, and motor vehicle offenses. And what we see is that African Americans are significantly disadvantaged regardless of the type of offense or program that they're enrolled in. So for example, African Americans who are enrolled in these programs in relation to property offenses were about 53%, or the odds of receiving a dismissal were about 53% lower compared to white defendants. We see similar patterns for drug and public order offenders, where Black defendants are charged with drug offenses were about 61%. The odds of dismissal were about 61% lower, and about 65% lower for those charged with public order offenses. Now, this last series of analysis looks at whether or not the type of pretrial intervention is going to impact the likelihood of dismissal. So as I discussed earlier, prosecutors have a wide variety of these programs, or a wide variety of ways or policies they can adopt to reduce disparities. So not only can they create specific types of programs like the pretrial intervention post-charge programs that I just talked about, but they can also just outright decriminalize certain types of behaviors without requiring individuals to enroll in specific types of programs. This particular analysis tries to get at what impact that might have on reducing racial disparities. And findings suggest that while Black offenders in general are less likely to have their cases dismissed when charged with a drug offense, those who are charged with some type of marijuana possession are about 2.4 times more likely to have their cases dismissed. And when we look at this interaction effect, we see that the odds of case dismissal is no longer statistically significant for a Black defendants charged with a marijuana possession offense. So that kind of leads us to think through, well, what is kind of happening when we create a decriminalization policy surrounding drug offenses. And I'm going to talk a little bit more about that in the discussion. So just a reminder, the purpose of this particular study was to examine the extent to which diversion programs actually reduce racial disparities in case processing. And I was specifically interested in whether or not pretrial intervention programs reduce racial disparities among case dismissals, and whether or not those programs or the type of program influences the extent to which racial disparities exist across pretrial case dismissals. Sorry about that. So one of the goals of these pretrial intervention programs is to limit criminal justice context. However, the findings from this particular study suggest that there are actually very few individuals, justice-involved individuals, who even get an opportunity to participate in these programs. So only about 4% of that 52,000 cases that are referred actually have the opportunity to even enroll in these programs. And of that percentage, Black defendants are significantly underrepresented compared to their presence in the number of referees, right? Due to the limitations of this particular data set, it's kind of unclear whether or not these findings are a consequence of prosecutorial discretion in offering pretrial intervention to individuals as an alternative to traditional justice system processing, whether or not program eligibility or criterion prohibit individuals from enrolling, so things like criminal history as a barrier, or if there are other barriers for enrollment, things like fines and fees. Now, prior research does allow us to kind of speculate on what might be happening here. So, for example, research kind of suggests that prosecutors are less likely to dismiss cases against minority defendants in general. And we've seen this also in the context of African Americans who are enrolled in diversion programs. Additionally, criminal history is going to play a really important role in this outcome, specifically as it requires individuals to have no criminal history or a very limited criminal history in order to participate in pretrial intervention programs. Courts and sentencing scholars consistently find that criminal history is a critical factor in decision-making behaviors for justice officials. And criminal history can have differential impacts on perceptions of dangerousness, culpability, as well as perceptions of whether or not a person has the ability to be rehabilitated. And given that African Americans face significant disadvantages in their likelihood of actually encountering law enforcement and becoming involved in the justice system, this just might be some type of like inherent disadvantage in barring African Americans from participating in these programs, regardless of whether or not they would be good candidates. And then lastly, pretrial intervention programs might also just be kind of cost prohibitive. A significant proportion of justice-involved individuals are economically disadvantaged. And because of this, program fees and fines related to these programs just may be restrictive, regardless of the cost that would be required to enroll. So if we just look at these three factors in totality, it might just be that African Americans are less likely to enroll in these programs because of these barriers. And so these PTI programs may just be inaccessible to African Americans. So they may not be the best way to reduce the disparities that we are hoping in these types of programs. These findings also highlight the influence of defendant race on defendant outcomes for those who actually did enroll in pretrial intervention programs, African Americans were less likely to receive a dismissal, and this is regardless of the type of offense. Again, just a reminder, generally these diversion programs require participants to complete a series of different requirements in order to have those charges dismissed. This can include anything like community service, going to individualized meetings with program staff, drug testing, a whole host of things. They may also require other requirements that would create additional burdens on participants. So finding employment, finding housing, making sure they're showing up for meetings, so having reliable transportation. And what we know from prior research is that all of these barriers are common to individuals that are enrolled in diversion programs, and that might actually influence their success. So, for example, if I'm enrolled in a program that requires me to find employment, it's very difficult for individuals with a prior criminal history, or if we're even thinking about substance abuse issues, to find employment, to find housing, and things like that. And so that just may be an impediment for the successful completion, my successful completion in these programs. And so it's really important for prosecutors to kind of consider that and consider what barriers there might be for completing these programs, and specific barriers related to African Americans. Also important to these findings is that this might be a function of the type of pretrial intervention that prosecutors are adopting. So pretrial intervention program requires participants to meet certain criteria in order to be enrolled, and to fulfill a number of requirements in order for their cases to be dismissed. In contrast, these decriminalization diversion options are generally less restrictive, and they may reduce barriers to actually participating in these programs, which may lead to achieving parity across different groups who eventually enroll. Findings kind of support this assumption. So when we examine case processing outcomes for individuals that are charged with drug offenses, and generally African Americans are less likely to have their cases dismissed. But when we look at that specifically in the context of those who are charged with simple possession, which is the type of decriminalization program that would apply to these individuals, we no longer see that racial disparity. Those differences are significantly reduced. And that might be for a number of reasons. One, these types of programs have much more flexible criteria. So again, just to remind us, in order to be eligible for these programs, criminal history does not matter. The only real significant factors are that a person not be currently under criminal justice supervision, so not on probation or parole, not have a concealed handgun at the time of their detention, not be detained in a drug-free zone or a correctional institution, and not already be enrolled in the program. So otherwise, any person can enroll in this particular program. Additionally, enrollment is not dictated by the prosecutor or not dictated by negotiations with the prosecutor. It's instead initiated with law enforcement following a detention. And so because of that, enrollment is voluntary. So individuals can choose to opt in or opt out of the program. The very design of this program might reduce the barriers to enrollment and increase participation for different marginalized groups. So prosecutors should really consider the extent to which program design might actually facilitate or impede goals of diversion. Again, diversion has a variety of goals, and so depending on what we expect to kind of come out of these programs, we really need to think about how these programs are designed. In contrast to pretrial intervention programs that are post-charge, decriminalization policies might actually be more effective at increasing opportunities for participation, which may ultimately lead to a reduction in racial disparities that we see in case processing. Thank you all, and I'm open to any questions or comments that you may have.
Thank you very much, Professor Henry. I want to urge that if anybody has a question, please do use the raising hands function on Zoom. If you're not familiar, you'll see down at the bottom of your screen a reactions tab, and you can use that to raise your hand, and I'll be sure to call on you. I know, Professor Henry, that you have some thoughts on the question of whether reduction of disparity is the right way to approach this as a policy matter, and what exactly the goal should be, and that you had some thoughts about whether equity or equality should be a goal. Could I ask you to share some of those thoughts?
Of course. So the findings specifically as it relates to the drug analysis were that for this particular type of offense, we reached a parity. There were no statistical differences between the treatment of Black defendants charged with simple possession and white defendants charged with simple possession, which is good. It's not a bad thing, right? And my kind of big picture question following that, though, is equality enough, or should we be considering equity in contrast? So historically, we know that African Americans have been significantly disadvantaged, particularly as it relates to drug crimes and drug offenses, and ultimately sentencing outcomes. So is it just enough to say, oh, well, we no longer see these differences, or should we be doing a little bit more for this particular type of offense?
Thank you, Professor. That's a really big question that I'm sure in some form we're all challenged to confront and wonder about in light of your findings. We did receive one question via chat from Jonathan. He writes, you mentioned that Black defendants might be likelier not to have the means to participate in pretrial intervention programs. But have you looked at the rates by race of acceptance, declination by defendants offered diversion, and correlates of those decisions, and then disposition of the cases of those who declined to participate?
Right. That was something that I would like to do. Unfortunately, that is not captured in the data. So that was a limitation of the data. I only had whether information on those individuals who actually enrolled in the program. So no information on whether or not a person was offered and then declined. And so that is a question that I think is really important. And that would speak to what prosecutors are actually doing. So the decisions that they are making, as opposed to what happens once folks are already enrolled in those programs. But with this particular data, given its secondary data and it's administrative data, there's no way that I could actually answer that question here.
Appreciate that. Good one. Kenitra, I see that you have your hand up.
I do. Thank you, Andy. I have a question about how strict program administrators were about participants not following certain conditions. Like, you mentioned that Black participants were less likely to have their charges dismissed, and likely because they weren't compliant with some condition of the program. And the one that stood out to me initially was you couldn't be in the program if you were rearrested. And I think it's easy to be rearrested when you're under supervision already, even if it's pretrial supervision, like for minor things, right? And you may not even be charged. Were those programs kind of being that stringent with participants? Like, you've got a barrier to housing, employment, transportation, or you've got a likelier chance of being arrested because you're already under supervision. It's criminogenic. Were those types of considerations being made with the program? And it's that question that makes me think that the answer to your overall policy question is not equality, but equity. Because again, if we already know that criminal history is a significant barrier to participating in pretrial intervention programs. That's impacted by bias and certain policing patterns anywhere. I don't want to guess where this is, but it's there, right? It's in the data. It's in the research. So I think the option is equity, right? Like, when you're talking about who can be in these programs, if you know that there are strategic barriers to entry in the first place that may be based in bias, that you may have to think about or offer alternatives to eligibility for the programs and grace for remaining in the program.
Right.
That's my answer to your policy question. Especially they're being stringent about participation in the program.
Yeah, thank you for that comment and breaking it down that way. Just to take us a couple of steps back and answer your initial question, I think that speaks directly to the variability that these programs have, right? Generally, the way these programs function is that there is a prosecutor for a special program, usually a defense attorney representing participants, and then a series of case managers linked to these programs, right? And the variability in how those individuals even view certain arrests or involvement with law enforcement, or a person having a dirty drug test, or whatever the case may be, is going to vary. And so where one person might say, I understand, like, you're having a difficulty here, I'm not going to, hold this against you this time. Another person might say, no, like, this is it, right? And so the differences in just that at that level is going to impact, what happens moving forward in a program. Again, this is secondary administrative data that doesn't speak to this. I'm speaking from other research that I've done with, like, this particular office, right? And so, but that is definitely an issue that we see, this variability in how individuals are perceived, how decision makers perceive the actions of individuals, as well as the starting places of individuals. So the barriers that they come into those programs with, right, are going to impact how well they do in the programs and their ability to be successful in these programs.
Thank you, Professor Henry. I see Director Worth has her hand up.
Sorry, I'm unmuted now. A quick question. I am curious as to whether you followed any or got any data on what happens to people who don't have their charges dismissed. And I ask that question because often in New York, for these diversion programs, people who don't complete the program are actually punished more harshly than if they had not attempted the program. And so there's a sense that people are actually punished for trying treatment or trying diversion and not succeeding, in addition to being punished for, the offense for which they were charged. So were you able to follow that information at all or track that?
That's a great comment and question. I did not do that for this analysis, but I do have that information. So that is something that I can look at in the future to see what the actual sentencing outcome was for individuals who did not have their cases dismissed. So that's absolutely something that I can do in the future.
Yeah, I mean, because if there's disparate outcomes for people based on race, and then they're punished even more for not completing the program, you can see how that just escalates the disparities in our system overall.
Yeah, and I wouldn't be surprised. I'm not actually surprised by that finding. I'm thinking in the context of other sentencing outcomes like trial penalties. So when individuals opt to go to trial as opposed to accepting a negotiated plea, they're generally punished more severely. We see that as well in other decision points in case processing. So when individuals decide to have an initial hearing as opposed to going to the grand jury, if probable cause is found at that initial hearing, they have more severe penalties in later case processing. And so that wouldn't be surprising to me that if an individual opted into one of these programs, did not successfully completed, that they would be punished more severely on the back end, because it's the idea that these resources were not utilized appropriately, and we're all about resources and efficiency in case processing, right?
Absolutely. Thank you.
Mhm.
Thank you. So we have a question from Caroline Cooper in the comments. She asks, were you able to get data on the number of and characteristics of arrests that were declined outright for prosecution? And as I understand that, that would be arrests that are, I know you described dismissals in your data, Professor Henry, and you're obviously describing in some context dismissals that are earned by participation in programs. As I understand decline to prosecution, that would be the law enforcement agency presents a file to the prosecutor and they don't even charge that person. They decide that's not appropriate. That may have been classed as a dismissal in your data too, but are you able to, and I may have missed it, are you able to respond to that question?
Yes, I can actually. So this particular analysis does not include individuals whose charges were declined initially. The data set does allow me to look at whether or not a person was referred by police or by law enforcement to the prosecutor's office, and then whether or not those charges were ultimately accepted. Just given like the kind of the nature of what the research questions were here, I didn't actually examine the declination decision, but that is also something that I could look into in the future. The way the data set is kind of set up, it is not like a yes or no decision in the data, but there is a way to kind of tease that out, whether or not the case was sent forward via or charged via information or charged via grand jury indictment. And so at that point, I can see, well, yes, these cases were charged, so no, they were not declined, right? But yeah.
Yes, thank you very much. I'm going to also reiterate Kenitra's next question that she put into the chat. And please, folks, do continue to raise your hands or put questions into the chat for Professor Henry. Kenitra, I'll do my best with this one. I might not get all the elements. But you ask, do you think the non-prosecution policy, that is to say, in the case of the drug cases, the non-prosecution policy that a person could qualify even if they did have a criminal history, as I understand it, do you think that that policy is the primary reason for the lack of disparity in the drug intervention program? And do you see the same possibility in other, presumably non-prosecution programs for theft or other offenses?
I do. I think the reduction of barriers to participating in that program is probably what is driving the reduction in disparities that we see. If it's easier to participate and enroll in a particular program without all of the caveats and without all the additional restrictions, you just may have more individuals opting into that program, as opposed to if you're presented with an option that says, I'm going to dismiss this case, but in order for me to dismiss this case, you have to complete X, Y, and Z, steps 1, 2, and 3, jump through this hurdle and that hurdle. I might just say it's not worth it, right? I might just, take the plea, take whatever charge, and like go on with my life, as opposed to, in this particular program, seems fairly easy to participate in, going to a class for 2 hours and never having the charge even appear unless I don't complete that class in 90 days. And so I do think that that type of program design is what is leading to this reduction in disparities for that type of offense. And I do think it can be applied to other types of offenses, especially if we're targeting these low-level non-violent offenses. As I mentioned previously, the majority of these offenses were misdemeanor B offenses. These are really low-level offenses, right? So some of these programs may not require the level of intervention that we think that they would require. Most people who are committing crimes or offenses that at that level may self-correct on their own. And so we may be able to just kind of take a step back and allow individuals to do that with these more hands-off approaches and compare and save those resources for folks who might really need it, right? So I hope that answers your question, Kanisha.
Yes, thank you.
Appreciate that. I see we have a question in chat from Juan, but I saw Beth's hand go up first. So Beth Williams.
Hi, I'm curious, and you sort of answered.
I'm sorry, I can't hear you.
Oh, you can't hear me?
Oh.
I have to put my mic back down.
Thank you.
Okay. You sort of answered this in answering Kanitra's question, but I was wondering if you were able to tell whether the services that were offered were related to the charges, right? Because I have seen in other fora that you have folks just say, well, here's what we ask people to do. And everybody gets asked to do that. And
Mm-hmm.
and maybe if you have a person of color, they get asked to do extra stuff. But I'm wondering if you were able to tell whether they really were sort of tailored to what was going on. So for example, if somebody asked to drop a urine test where drugs weren't involved, but we've just decided that that's something that we have to look at.
So the requirements were tailored to the specific programs that individuals were enrolled in. So for example, the DWI program required individuals to have individualized assessments conducted and to meet with deputy prosecuting attorneys to talk about their offense. They also had to write a letter after they took a class describing, why what they did was wrong and X, Y, and Z. That was not the requirements that were related to the retail theft program. The retail theft program also required a class, but they had different stipulations. The drug program was the main program that would require drug testing, and that program was a little bit more intensive. The mental health program, again, required different, was associated with different factors. So all these programs had different requirements and different qualifications in order to have the cases dismissed.
Great, thank you.
Thank you. So Juan's question is, he asks, your project appears to be founded on the premise that diversion serves as a solution to over-prosecution. However, there is existing research indicating that diversion can inadvertently become an alternative form of punishment. Do you have thoughts on how to remedy that paradox?
Yeah, I think that's a really great question. And it's something that I've been in talks with folks a lot. And I think the answer to that depends on how these programs are actually administered. I do think some of these programs can actually act as diversion, can actually divert individuals away from the criminal justice system and achieve the goals that are kind of ascribed. So achieve this goal of public safety, reduce criminal justice contact, things like that. But I think sometimes we get in the way of that in the way that we administer those programs, right? And so if our goal is to limit criminal justice contact, but then we require folks to contact us for a number of instances or days or whatever the case may be, that's not really meeting the goal that we would have established, we wanted to establish with this particular program. If our goal is to reduce criminal justice contact and we rely on a decriminalization program and we're a little less strict or restrictive, that might actually achieve the goal that we were hoping to set, or the thing that we were hoping to do. So I think it depends on the way that these programs are actually administered, whether or not they actually become even more punitive options.
Thank you. I want to keep urging people to put questions in the chat or raise your hand. I'll ask one of my own right now, seeing a little lull. Professor Henry, I actually want to ask you about, I kind of want to ask you about what your theory is about how these programs might reduce disparity. As I sort of imagine it going into this, if you're trying to design a program to affect disparity in the criminal justice system, there are sort of three possibilities. One is you're successful and at the end there's less disparity. One is that the program just enrolls everybody at the same rate and it might benefit those people, but doesn't have a disparate impact. And the other, and I see some signs of this in your results, is that actually what the program does in some cases is it benefits the people who are already advantaged. So all the people who might have been dealt with less leniently are then more likely to get into the program, then more likely to succeed in the program. And so it becomes a story, and parts of your results I saw as a story a little bit like that. And also, as you contrast these two programs, one of which has the criminal history exclusion and the other which doesn't, it sounds like the story is very much about cumulative disadvantage in the background. That you've got some people who are excluded, and if they don't fall at the first hurdle, they're more likely to fall at the second hurdle. And in the end, the people benefiting are the people who had the most advantage at the beginning. And that, I would think, as an outcome, is probably the most disappointing. Because if you want this program to go and actually reduce disparity, in the end, it's helping some people, but it's in a disparate way. It's helping the people who needed the least help. And the people who you really hope to help in order to reduce disparity aren't getting into the program at all. And I remember that when we in Dallas at the center were able to study the decision by the DA to stop charging marijuana cases, we actually end up concluding that what had happened was the middle option. That what happened is they were certainly prosecuting nobody for marijuana anymore, but that had it didn't have a disparate effect. They just weren't. They'd ceased to prosecute white people. They ceased to prosecute black people. There were many black people who were being prosecuted, so that was those people were no longer being prosecuted. But it wasn't disparate. It was just sort of helping everybody in proportion equally. And when we got that result, I just thought, well, whatever was our theory? Like, in fact, the most obvious thing these programs would do is not to help disparity. It would just to help everybody equally or something like that. So I guess I wonder, were you disappointed? And I also wonder, like, in light of your results, do you think that if we want these programs to tackle disparity at all, we just need to design them differently? Like, how would you design a pretrial diversion intervention that would actually address disparity as opposed to just sort of almost reinforcing it?
That is loaded. Okay, I'm trying to take it a piece at a time. I'll start with the what would I want these programs to look like and the goal of attempting to accomplish them. I've talked to a lot of people, folks in the community, public defenders, criminal justice decision makers about the efficacy of these programs. And what I've heard from them is that a lot of the times we don't actually need pretrial diversion. What I've heard is that actually if we're going to send a person through pretrial diversion and at the end of that time you're just going to dismiss the charge, then what's the point of sending them through pretrial diversion? If what they did was so non-impactful, if it was low, if it was truly low level, if it was truly like not a severe offense, then why put them through this process in the first place? How is this impacting public safety? What is this doing for the community and the betterment of the community? And so when I think about how we design these programs, I want to keep that in mind, right? What is the point in making a person participate in this program? What are our goals for this program? Is it treatment? Is it public safety? Is it a combination of those things? And I think we have to when we design these programs, that's what we need to keep in mind, right? So, for example, with the decriminalization of marijuana program, is the goal there just to ensure that we are not influencing mass incarceration, influencing severity and punishment for particular groups? And if that's the goal, then this program might work. Let's check the box off there. If the goal is something different, are we not achieving that? And what does that, what does that program look like? And so I really think when we design these programs, we need to keep in mind what our ultimate goal is. And is it just to not have people in the criminal justice system? And if that's the case, that's okay, right? But what do we actually want to achieve with these programs? I think some programs are, I would say, in an effort to decriminalize some behaviors, are better at that than other programs, or maybe better at that than other programs, because it takes the decision makers element out of it, right? And places it on the actual individual who is justice involved. I hope that answered your question, at least answered part of your question.
Yeah, thank you very much. So, and Patricia wrote in the comments at the same time, to reframe it a bit, are we using treatment as a punishment? That reminds me both of Patricia's first question and also of Juan's question. What do you think of that comment?
I think in some instances it may be. I think treatment is very beneficial. And I would not say that we should get rid of these programs in their entirety. I think we have to maybe rethink who these programs are actually serving. We want to make sure that we're serving the justice-involved individual person who is enrolled in that program. And if we're not doing that, if it's just we need you to go through part 1 of this program, part 2 of this program, part 3 of this program, and then you graduate and that's it. I don't think that's a good administration of a program like that. I think we have to always consistently consider who are we actually serving there. And the first individual that we're serving is the justice involved person.
Yeah. It seems to me that one way that if you had other data for the future that you might be able, but I wonder if you have it, would be to compare and contrast the people who did complete the programs with the people who never enrolled on their continuing entanglement with the criminal legal system in the future, if that actually happens. Does that make sense? And is that something you might have an opportunity to do?
That does make sense. I do not have the longitudinal data to assess that. My data stops at a particular fiscal year, and so I wouldn't be able to follow folks throughout the system.
Right. Well,
but if they give me more data, then maybe I could do that. I could track it that way.
Well, I want to tell you something. Oh, I see we have a new question in the chat, but if I'm not mistaken, there's the state with state jail felonies is also the state that we're located in. And in that case, the Department for Public Safety just had a policy change about getting computerized criminal history to researchers that should go into effect on September 30th. And I'll connect with you about that because there really might be an opportunity there.
Thank you.
Yeah. Kanitra says, another observation, it always stands out to me when the data doesn't accurately capture ethnicity, because then we don't really know if certain behaviors, processes, etc. are exacerbating disparity. I recall that your Latinx data, I think, had missingness problems. And
yes.
Is that right? Could you speak to Kanitra's, would you like to speak to her question a bit?
Yes, so there were significant issues with the measurement of Latinx defendants in the data set, particularly those enrolled in pretrial intervention programming. In the more broader data set, that information is captured a little bit better. But for individuals enrolled in these particular programs, it was significantly missing. I think about 86% of that information was not available, which is really unfortunate, particularly given the location of this particular prosecutor's office, because they would more than likely have a significantly high number of Latino defendants being processed through that system, again, just based on the location generally. And so I think we have gotten better at attempting to capture race and ethnicity in administrative records. I think we are nowhere near where we need to be in order to, one, better understand what these effects are, and also better understand the populations that we're serving. We don't do a great job at that, and it is quite unfortunate. There's a significant difficulty in differentiating between race and ethnicity, asking that as two separate questions as opposed to one question. And so that causes like a whole host of issues when we're trying to separate those out into different distinct categories. So.
Thank you. We've probably got quite a time for one more if anybody wants to stick their hand up or type something into chat. I take it, Professor Henry, that your recommendation is to design programs that are, let's say, at least more forgiving of people who might have records of prior criminal legal system involvement. I did notice that even for the drug program, as I understood it, people under supervision were not eligible. I wondered if that was right, and then I sort of wondered, how far would you push it? I mean, in your view, should those people have been eligible, in fact? Right,
yes. So for this particular county, the way that this works is that those individuals who are currently under criminal justice supervision are not allowed to participate in the program. And I'll take a step back and say, one, I think we do really need to reconsider how criminal history is used as a way to limit the number of individuals who are allowed to participate in these programs. Mostly because we don't do a really great job at understanding the time length of criminal history. So if it's just any type of criminal history, and that's going to bar folks from participating in these programs, well, what happens when my last criminal history offense was 5 years ago, and this is like the most recent thing that I've done? Is it fair that I don't get to participate in a particular program, right? How is criminal history actually impacting individuals' ability to enroll in these programs? Is really important for folks to consider. I would argue that a person who has a 5-year-old criminal history, it shouldn't really matter, right? Because that was 5 years ago. What is it when your credit score just like stuff just falls off after every so many years? Why do we not do the same thing for criminal history, especially if it's like a low level nonviolent type of offense, right? That is something that we need to consider, how we use criminal history as a way to restrict participation in these programs. Absolutely. Do I think individuals under criminal justice supervision should be barred from these programs or ineligible from to participate in these programs? Personally, no, I don't think that should be the case. And again, this goes to, if we're going to decriminalize a particular type of behavior, why would it necessarily matter that I am under criminal justice supervision? I get the legal reasons why it matters, but for non-legal reasons, I think it should matter less. I think we should consider applying these types of policies to all individuals, as opposed to restricting it to particular individuals simply because they are under criminal justice supervision. Because again, similar to criminal history, a person can be under criminal justice supervision for years, right? And if we are decriminalizing this particular behavior because we don't think it is actually causing harm or is harmful, then shouldn't that be applied to everybody? Again, that goes back to why we're doing the justifications for why we're doing what we're doing.
That's a brilliant point. I'm certainly persuaded by it on principle, and further, I think it goes to your central theme of disparity, because as I understand it, any such consideration as whether a person has had that is a reflection or a product of the fact that a person has had any prior criminal justice entanglement at all is going to tend to perpetuate cycles of disadvantage, as I understand it. And so if that's true, I think it has to follow that the only way that such a program could reduce disparity would be by first stripping out consideration of prior involvement. That I think that has to be a part of it, logically, as much as possible, for these programs to accomplish that kind of effect at all. So that was what was occurring to me when I asked it. Yes. Anyway, all right. Well, thank you very much, Professor Henry. I don't see further questions in the chat right now, or any hands up. So I think that everybody's had a really good chance to think about what you presented, and I'm very thankful for what you did present. I was certainly extremely compelled by it, and I thought that you had a number of really important interacting themes. I mean, you had not just the decriminalization, but also the pretrial intervention. You had the question of whether these things were reducing disparity, but you also, in response to people's comments, were going quite deep into the efficacy of these programs across all people. It seems like you've got lots and lots of possibilities for, further growth of the analyses should other data be available. And I'm just very thankful for you sharing this. I hope very much that it was constructive for you. I did put a link in the chat about this new computerized criminal history law in Texas. I hope that it has the desired effect of allowing us now to follow people over time using their name or their state, their SID number, and actually see whether people are coming back into the system or not. But I'll follow up with you directly also. I don't have any other questions, and I don't think anybody else does either. But thank you so much for your presentation. And as I say, I hope very much that this was useful to you. And if anybody has parting words, including you, Professor Henry, please do speak up.
I do just want to say thank you so much for the opportunity. This was really, really great. I will admit I was a little nervous doing it, so this really went really well. I appreciate all the comments and the feedback on the project, and I'm definitely going to incorporate, or to the best of my abilities, given the data restrictions, incorporate some of your comments into further analysis. So I really, really do appreciate it. This was a great experience. Thank you all.